Hello, everyone. Thank you for coming to this training on the Right to Know Law and the Sunshine Act. Apologize for having to reschedule it due to the nor'easter, but I'm glad you're all here today. I know a number of township officials were unable to come today, so they're obviously not here. This training session is going to be recorded and posted online on the county's website. So if you ever need to fall asleep faster some night or whatever, you can watch this training over and over and over again. That's okay. My name is Chad Schnee. I'm the first assistant county solicitor for the county of Berks. Prior to my role here, I was the assistant chief counsel for the Office of the Records and served as an appeals officer for about 6.5 years. So George is free to blame me for anything that, a bad interpretation of the right to know, you can blame me, that's okay. Questions? We do have 90 minutes of full program scheduled today, but if you do have questions, we can take a few brief questions during the program. Otherwise, we have index cards outside. You can write down your questions if you forget them, and come up to us afterwards. We'd be happy to help you out. Also, if you are an attorney seeking CLE credit, this program has been approved for 1.5 hours of CLE credit for $10. If you go outside and see Mary Jo Gibson, she'd be happy to help you out. Also, Mary Jo Gibson, our open records officer, will have index cards that we can collect along the way if you have questions and want me to ask it or someone else to ask it. Finally, I'd like to say thank you to the Albright Center for Excellence in Local Government, the Berks County Bar Association, also the County Solicitor and the Board of Commissioners for allowing me to host this event, allowing the county to host this event, and also for their commitment to open government. Finally, I'd like to thank the Pennsylvania Office of Open Records, who generously donated their time today to come out and provide this training. With that, I'd like to turn it over to George Spees. George Spees is my fellow co-employee, or fellow employee, or co-worker rather. He's the Chief of Outreach and Training for the Office of Open Records. He's responsible for providing these trainings, and he also serves as the Open Records Officer for the Office of Open Records, which itself receives about 1,000 open records right to know law requests per year. He's also the guy, if you call the Office of Open Records, he'll probably pick up the phone and give you whatever kind of information, whatever help he can give you, and also email as well. So with that, George Spees.
Thank you, Chad. And we'll see if you feel that way at the end of this session. Okay, we have a lot of territory to cover here this afternoon, so some of the information that you'll see on the slides but yet are included on your handouts, I may just brush over. That's not intended as a slight of any way. I just want to make sure I touch on the important points. And you still have that information so that if you do subsequently have questions, again, feel free to pipe up or fill out one of the index cards or just come see me after the session. I'm more than happy to hang out for as long as it takes to address any issues that you may have. But let's jump right into this. The Right to Know law as it currently exists became effective January 1st of 2009. Prior to that, Pennsylvania had what was known as the Right to Know Act. Under that act, if I were a citizen and I came to a government agency and requested a record, let's say for whatever reason you denied me that access, I bore the burden. I had to take you to court. I had to prove to a judge as to why that record should be released into the public domain. January 1st, 2009, that changed, 180 degrees. Now, if I'm a citizen and I come to your agency and request a record through the Right to Know process, and let's say you deny me that access, you bear the burden. You have to prove to an appeals officer or possibly a judge as to why that record should not be released into the public domain. So basically the takeaway from this is that when in doubt, you presume that the record is public and that it should be released, and then you work from that point backwards. Now, that sounds rather daunting. However, during this presentation, I'll show you that there are a number of tools that an agency can use to withhold a record from the public domain if they feel it's justified to do so. And hopefully you'll take some of these useful tools back with you to your program. The other thing that happened is it created the Office of Open Records, which is where I work. Prior to the enactment of this law, there was no central department, no central office that oversaw public records within the Commonwealth of Pennsylvania for either state or local records. Okay, so who's subject to the right to know law? Well, at the state level, I think the question is better answered by a different question. Who isn't subject to right to know? Every cabinet level agency, department, board, commission, any authorities created by statute, same way at the local level, it would be cities, boroughs, townships, school districts, again, authorities created by statute. It depends as to whether the entity is performing a non-ancillary government service, which is a legal terminology that basically says, is it something a role government would historically have performed? In some instances, that can be very subjective. I'll give you an example. Public libraries is always an interesting one, because you can roll into one borough, small borough, and let's say their public library is a completely independent entity from the borough government. They have an independent board of directors. If they were to have like a chief librarian who's an employee of the organization, they're paid by that freestanding library, and there's no real connection between the borough and the library governance itself. Chances are that library would not be subject to right to know. But then you could go 3 miles down the road to the next borough and you run into an entirely different animal, where the public library is actually part of the organizational structure of the borough. If there's like a head librarian, they're a borough employee, and the library's budget is actually a line item as part of the borough. Chances are, in that scenario, the library would be subject to the right to know, given how it's structured. So you look at it on a case-by-case basis. Another area that we could spend some time talking about, but I'm not going to get into great detail, are volunteer fire companies. As it stands right now in Pennsylvania, 62 counties, volunteer fire companies are considered subject to right to know. In 5 counties in Pennsylvania, they are not. It's simply because there's yet to be a statewide court decision determining whether or not volunteer fire companies are subject to right to know. So there are still issues that need to be worked out when it comes to jurisdiction. But I think for the most part, if it is a government entity performing a government function, it would be subject to right to know. Just because an organization is receiving government funds does not subject it to right to know. You have to look at what the organization is doing, its governance, its structure, et cetera, et cetera. I'm sorry. Legislative agencies, this refers to the Pennsylvania House, the Pennsylvania Senate. They are subject to right to know, but they have their own system, more or less. You would file a request with their right to know officer, and if they chose to deny that request, the appeal would also go to them as well, which is not the case with other agencies. Judicial agencies, they are subject to right to know, but only for financial records. That is because in Pennsylvania, under common law, most court records are already considered public. And also the court system has a fairly rigorous internet presence with AOPC, so most court records you can already find, so it wouldn't make sense to have a duplication of effort by making them subject to right to know for court records other than financial documents. Okay, so let's say the agency is subject to right to know. There are certain obligations that they have. The most important being that they have to appoint an agency open records officer, what we refer to lovingly as an ARO. This is the person who is responsible for receiving the requests, processing the requests, and then responding to the requests. The law is silent on how you organize your open records officers and the reporting relationships. You can have one entity where there is one open records officer that oversees everything. Then you can go to a very similar sized borough or township, and they may have 2 open records officers, one overseeing the administrative side and a separate one for law enforcement. That's okay, as long as it's clear to a requester who they should give their open records request to. I believe the city of Philadelphia currently has 38 open records officers. given the size of their organization and the scope of services that they provide. Again, as long as it's clear to the requester who they should give the open records request to, how you organize your program as your business. Open records officers are not really required to have any training. They don't need to be sworn in. They don't need to be voted on by a board. Most open records officers gained that title the same way I did. One morning I was sitting in my cubicle minding my own business when my boss walked in and said, "Hey George, guess what? You're now the open records officer." Congratulations. Agencies may promulgate their own regulations, their own rules for administering their program, so long as it's not in conflict with the law. What are some examples? Well, for instance, the law says that agencies may accept anonymous requests. Well, because that word in there is controlling it is may, it also means may not. So if you wanted to, you could adopt a local policy that basically says you'll only receive requests or entertain requests from parties where they have identified themselves. You won't accept anonymous requests. You can do that at your discretion. Just make sure that you apply it uniformly and equitably. Another one has to do with verbal requests. The law says that you may accept verbal requests. Again, that also means you may not, if you so choose and you want to pass a policy that reflects that you would only accept right-to-know requests that are in writing. I'll editorialize a little bit. I think that's probably a good policy to have. Because the problem with a verbal request is I can walk in to your counter and say, hey, this is a verbal right-to-know request. I'd like a copy of the budget. You can look me square in the eye and say, this is a verbal response. No. And there's absolutely nothing I can do about it. I can't file an appeal because there's no documentation memorializing that interaction. So I think it's probably best for all parties to have those right-to-know requests in writing whenever possible. You can create your own right-to-know form at the local level. Many agencies do. They like to have their seal at the top, maybe information about how to contact their open records officer. If they've passed any local regulations, that might be included on the form itself. However, you must also accept the state uniform form, which is on the Office of Open Records website. Many agencies simply link to that, and that's fine. You can do that. Finally, we ask that you provide our office with the name and contact information for your open records officer. You can actually register online on our website, and then it goes into a database, and we have spreadsheets available on our website with this information. It's a voluntary system, so they're not always up to date, and if you happen to be from a local government or if you're an open records officer, maybe you want to check our website to make sure it is up to date. And if we've missed something, then you can correct that online, because we like to have that information current. Okay, as far as postings go, well, you're not required to have a bulletin board, but if you do, you got to have information about the right-to-know law there. Most particularly, information about your open records officer. Who is that person? Who do I give my request to? Any information about how I would file an appeal if you would happen to deny my request. Also, any information related to those policies that we talked about, so that there's no surprises. I know what I'm dealing with if I'm a requester. And then finally, a copy of the form, the actual form, so that if I don't have one, I can pull it off the bulletin board and use it, or else maybe ask for a copy from your office so that I can file the request right there. You're not required to have a website, but again, if you do, you have to have information there about the right-to-know law. I think it's probably best, and the most common practice seems to be on the home page, down at the bottom, there's a link, Right to Know, which then takes you to a page which would have much more detailed information about the right-to-know law and your right-to-know program on there. Okay, under the right-to-know law, there are some things that you cannot do, so you need to be aware of this. The first is that you cannot limit the number of right-to-know requests that a person files within any specified time period. You can't say, now I'm sorry, you've already filed 3 requests this week, that's all you get. If she feels compelled to file 12 requests that week, she's allowed to. You cannot limit the number of requests a person files. The other thing that you cannot do is compel a person to tell you why they are filing the request. You cannot deny a request based on the reason or what you think that reason might be. And as Chad mentioned, I'm the Open Records Officer for the Office of Open Records. Couldn't fit that on my business card, but we sometimes see people use the right to know law really just to be a pest. And I think I'm being diplomatic when I use that term. It would be great if we could send them packing and say, look, you know, this isn't what the law is about. Sometimes you think the reason that they're filing the request is just to see me work harder. Life isn't always fair, but this is what the law says. And hopefully I'll provide some tips later on how to deal with difficult requesters in certain situations. But the bottom line is that even if you think they're filing a request maybe just to dig up dirt on a public official, maybe they didn't like the size of the tax increase last year, or you know, maybe they got cited for not mowing the grass or whatever, so they decided they're going to get back at you by filing right to know requests. Unfortunately, the law allows them to do that. So you cannot deny a request based on the reason or what you think the reason is, and you can't even go so far as to require them to tell you why they're filing the request. Okay, I talked about tips and tools. I think this is probably the most important one. This might be the most important slide that you see here this afternoon. And it is the definition of a record, which is included in the right to know law. And essentially, it represents the first cut that's taken when a right to know request is received. The first question that's asked, are these documents that the person's seeking, are they in fact records? Do they meet this definition within the law? Let me just read it here real quick. Any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is created, received, etc., etc., etc. The key phrase I have highlighted, documents a transaction or activity of an agency. That's the question that needs answered. Do these documents in fact do that? I'll give you a quick example that hopefully will be helpful. Let's say that I am a township supervisor. And I'm sitting at home in my family room. I'm on my personal computer, and I'm on my personal AOL account. And I send a message to one of my colleagues that my daughter has a softball game tonight. I'm going to be about 20 minutes late for the meeting. Now, that message is what we call transitory. It's basically personal in nature. I'm simply telling a colleague I'm going to be about 20 minutes late. It has nothing to do with, really, my authority as a township supervisor, business before the board, or the impact any business would have on the public. It's a personal message. And chances are that if a right to know request were received from my emails, that message would not be included in the responsive records because it doesn't rise to the definition of a record per the Open Records Law. Now I'll change this example up a little bit. Let's say I'm that same township supervisor, same family room, same computer, same AOL account. And I send a message to my colleagues. I understand at tomorrow night's meeting, this proposal is coming up to revise an ordinance. I have some concerns about that. Here they are. And quite honestly, at this point, I'm thinking about voting against the proposal. Tell me what you think. Now, number one, I've just violated Pennsylvania's Sunshine Act because I'm deliberating outside of the public eye. But more importantly, that message, given its content, clearly would be considered responsive to a request for my emails regarding a particular subject. Because I'm exercising my authority as a township supervisor, my role. It's business that's clearly coming up before the board and would ultimately have an impact on the public. So in the second example, given the content of the message, it does rise to the level of being considered a record and would be responsive to the request and most likely would be provided in response to that right to know request for my emails. Now, if you've taken note, I'm at home. I'm on my home computer. I'm on my personal AOL account. But yet, given the content of the message, I'm still generating public records. Okay, you cannot use personal devices or personal accounts to hide the public's business, they would still be considered public records and would still be expected to be provided in response to a right to know request. The other part of that definition dealt with any physical form or character. I'm not going to spend a lot of time on this, but I think it's interesting to see that since 2009, well, back in 2009, if I would mention public record, for most people, the image of an 8.5 by 11 sheet of paper would pop into their heads, and I think that would make perfect sense. The right to know law also accommodates electronic records, so we're talking about emails, Word documents, Excel spreadsheets, various database applications, and the like. However, since 2009, we've seen a literal explosion in the types of technology that are used to conduct the people's business. And I think it's being reflected in the types of right to know requests that we see and the types of cases that are being decided in both the Office of Open Records and through the courts. People, they want to see phone records. Who are the public officials talking to? So we see that reflected in requests. Text messaging. This is an interesting one because text messaging can be a very efficient form of communication as well as memorializing conversations and creating public records as we're doing so. And I think particularly with the younger members of the workforce that are coming up through and using cell phone technology to conduct the public's business, we're seeing more and more text messages being requested through the right to know process. Blueprints, I only put that out there because a lot of times when I go into, for instance, a smaller township where you walk into the conference room and maybe there's a new subdivision coming in, or a big thing now are stormwater drainage and runoff projects taking place. So they'll have the blueprints for that project displayed on the wall. Well, just because it's larger than an 8.5 by 11 sheet of paper doesn't mean it's not a public record. And if a right to know request were received for copies of those prints, again, depending on the content, they very well could be considered public records, and that township or borough would be obligated to provide a copy of it. Audio recordings, again, new technology. Most public meetings are recorded, usually for purposes of producing minutes. As soon as that meeting is concluded, that audio recording is considered a public record. Now, let's say it is for purposes of keeping minutes. Well, next day, the secretary sits down with a copy of the recording, which is basically what I'll portray as a verbatim transcript. But per the Sunshine Act, the minutes that you're required to keep are much more abridged. It's basically the time, place of the meeting, who was there on the board, what business was conducted, and how did they vote, yea or nay, and then public comment. Okay, that makes up your minutes. So you've prepared, the secretary prepared the minutes from the recording. Under the right to know law, those minutes are now considered draft. And there's an exemption within the law that would allow you to withhold them if you wanted to until the next regularly scheduled meeting of that board. At that point, the exemption no longer applies and the minutes are considered a permanent public record and would have to be released in response to a right to know request. Let's go back to the audio recording. Let's say once those draft minutes are produced, that the secretary erases the file or records over the tape or takes the cassette, throws it in the trash, that's okay. You have not violated the right to know law because there is nothing in the right to know law that addresses the retention of records. So that if you have a sound business case for destroying a record, whether it be stale or you just have no longer a need for it, you can do that and you are not violating the right to know law when you destroy or delete that record. Now, security camera footage, I only put that out there because we're seeing more and more security cameras. Increased concern over security, decreasing costs of technology, depending, again, what's on the record or what's on that video, it could be a public record. It depends on the content, but you just need to be aware of that. Social media, this is an interesting one because we're seeing more and more use of Facebook, Twitter, Instagram, and the like by public agencies to get the word out. I mean, it's being used for all the right reasons. It's good technology. You just need to be aware that when you do that, you are creating public records. And even behind the technology, for instance, a Facebook page, if you receive an inappropriate comment and you delete it, okay, there's a record of that. And then if you ban that poster from further comments on your page, there's also a record of that. And dependent on the nature of the request, you may have to go into Facebook and secure that information and provide it in response to the request. As an aside, I'll recommend that if you are using social media, you develop a social media policy, have it approved by your solicitor, because we're seeing a trend nationally of court cases where, just like what I spoke of, someone puts a comment on a Facebook page that's maintained by a government agency, they go in and delete it, that person turns around and files suit. Well, you've abridged my right to free speech because you've deleted my comment and you've banned me from further posting. There have been some substantial cash awards because of that. So, if you have a policy in place that's legally defensible, it might save you some money. But like I said, you're using social media for all the right reasons. I think you should continue to do so. You just need to be aware that you are generating public records as you do that. And finally, dash and body cams. This mainly applies to law enforcement, but it is a sexy issue right now with right to know law, because we're currently waiting for a decision from the Pennsylvania Supreme Court on a case called Grove versus Pennsylvania State Police. That will hopefully provide guidance on how agencies should respond when it comes to requests for dash cam video, body cam video. Again, as an aside, we mentioned just law enforcement right now, but if you were to go out to the West Coast, it wouldn't be unusual to find a public works employee wearing a body cam. Why? Well, it could be that they're working on a project that they want to make sure there's a recording of it for training purposes, maybe for quality control, or maybe they have to go door to door to notify citizens within a certain geographic area of something that's going on. By having the body cam on them, memorializing that conversation to make sure that it took place, to make sure that it took place properly. So it's coming. I mean, we're seeing, like I said, an explosion in the types of technology that are being used to conduct the people's business. And I wouldn't be surprised if a couple of years from now we saw the same thing here on the East Coast. If you want to know what technology we're going to be using 3, 4, 5 years from now to conduct public business, ask your kids what they're using now. And that'll give you a fairly good idea. Okay, who can make requests? Well, the law states it's any legal resident of the United States. There is no residency test defined in the law, and really it just hasn't been an issue. It hasn't been tested either by our office or the courts as to what constitutes a legal resident under the right to know law. So I'm not worried about it too much. Under statutory construction in Pennsylvania, a corporation can file a right to know request. They have standing. So if you receive a right to know request from a corporation, you should treat it as a valid request. Also, one municipality can file a right to know request with another municipality, and that's not unusual. For instance, I happen to know, given some phone calls to my office, that Elk County is getting ready to go into contract negotiations with their unionized staff. How do I know that? Because I started getting calls from the counties around Elk who were receiving right to know requests for salary information and copies of their bargaining unit contracts. And I happen to know the right to know officer for Elk County, so I called them up. Said, hey, are you guys getting ready to go into contract negotiations? Like, whoa, how do you know that? And I told them about the phone calls. It's not unusual for one municipality to file a right to know request with another municipality, and they can do that. Okay, a proper request, well, there are some things you need to look for. And first and most importantly is that it needs to be addressed to the open records officer. It doesn't have to say the person's name. It can say open records officer for County of Berks, and that's sufficient. But it needs to be clear that this request should go to the open records officer. All of your staff should be trained that if they receive an open records request, that it needs to get to the open records officer as soon as possible. There are hard deadlines built into this law. Requests are time sensitive. The agency has a finite period in which to respond. So you want to make sure it gets to the open records officer as soon as possible so they can begin processing it. So make sure all your staff is aware of that requirement. Open records request or right to know request, it's the same thing. They get that, okay, I've got to get it down to the open records officer. It can't sit in an inbox, it can't sit on a counter, or wait till next Wednesday when I'm planning to go downtown to get it to the person. You need to come up with a system to get that request to them as soon as possible. Here's a good tip for you in that the intent of the right to know law is to give the public access to records. It's not intended for them to simply ask questions and then for local government to function as like Google and search around for answers. The request must be what we call sufficiently specific. That's taken out of the law. Basically, it means that a request must be sufficiently specific enough that if I'm looking at it, I can determine a body of records that are responsive to what the person is looking for. So maybe I submit a right to know request that asks the question. For instance, I want to know why the supervisors voted for this particular vendor for the snowplow contract. I haven't asked for a record. So if I were a literal interpretation of the law, by rights you could deny my request because I'm not asking for a record. But it begs the question, is my request still sufficiently specific? Are you able to figure out a body of records that's responsive? Well, I would say that given the fact that you're good public servants, you're going to make the connection. Maybe pick up the phone, send me an email, say, George, would it be helpful if we sent you copies of the bid submittals that were used by the supervisors to select the vendor for the snowplow contract? And I'm going to say, well, yeah, that's what I was asking for. So you're going to send me that information in response to my request. I'm going to be happy. I get what I want. You can get back to the important work you were doing before I started bothering you for this stuff. Okay? So that's the crux here. And I realize sometimes it's hard and sometimes it's subjective because a surprising percentage of appeals that our office deals with still deal with this issue. Is it sufficiently specific? We've seen some court language that's provided some good guidance, but it's something that we're still wrestling with. And I think one of the biggest problems is you receive a request, it's not from an attorney, but it's from a person who plays an attorney on TV. And you look at it and it's like, what the heck? Honestly, if you can't figure out what they're asking for, you can deny that request because it's not sufficiently specific. Okay? Let's move on. So when you receive a request, if you're the open records officer, if you're working for the open records officer or with them, first thing you need to do is note the date that you received the request. Because again, like I said, there are hard deadlines built into the law, so you want to make sure that the date is noted on the request because that could become critical at the time of perhaps an appeal being filed or looking at the timeliness of responses and so forth. You have 5 business days in which to provide an initial response. So if the request were received today, tomorrow would be your first business day. Also, we should note that it's your business days at the local government level. There are some organizations, there are some small boroughs in Pennsylvania that don't have an office. All of their records basically are kept in a shoebox in the secretary's bedroom closet. The council meets quarterly around the mayor's kitchen table, and they don't have business days per se, but somehow they're always able to work it out. It really hasn't been a debilitating issue. But there are some times when they're not on a 5-day schedule. For instance, school districts during the summer break. Oftentimes, maybe they're only open 4 or 3 days a week. In those instances, the business days would be, just as an example, Monday, Tuesday, Wednesday. Then you go to week 2, Monday, Tuesday. So they get 2 weeks in which to respond initially through their 5-day window. Keep a copy of all information until the request is fulfilled. And while this isn't in the law, it's my recommendation. hold on to everything for 30 days, even if you think you're granting the request. Sometimes you think you're giving the person what they're asking for, and they get home and start going through it, and they're dissatisfied. You know, you've redacted all the good stuff, or maybe this isn't what I asked for. But rather than coming back to you for clarification, they'll simply file an appeal. Well, they have 15 business days in which to do that. So if after 30 days, if you haven't heard anything, either you're not going to, or if you do, chances are that appeal will be dismissed because it's untimely. After 30 days, you know, what you do with the information is your business. There are some agencies that hold on to this stuff for years. There are others that pitch it as soon as they no longer need it. The law, like I said, it doesn't speak to the retention of records. So if after 30 days you don't think you need it anymore and you want to throw it out, you can do that. It's up to you. It's your choice.
Just to clarify for one point, George, although the right to know law might say that you don't have to keep records for a certain amount of time, certainly the county records manual and other record retention guidance out there does require keeping right to know law requests and responses for a period of time beyond 30 days.
That's absolutely correct. Just because the right to know law is silent on retention, it doesn't mean that there may be other laws that apply to your organization that require you retain records for a certain period of time. You'll see when we get to best practices, I do address records retention a little more detailed and a little more forcefully. But let's move on. Thanks, Chad. Okay, there may be instances where you have to notify a third party when you receive a request. I won't dwell on this too much, but usually it's when you have a contractor providing a service for your local government, like the snowplow driver. You know, our township doesn't have snowplows, but we contract it out. Let's say I want a copy of the snowplow schedule, so that if there's a storm, I want to know how soon my street's going to get plowed. You don't have that. What your snowplow contractor does, you would be required to go to, actually, I'm sorry, I do this every time. I'm one slide ahead. Let me back up. So the reason you would notify a third party who's a contractor would be when they were bidding on the contract or when the contract was let and there was an exchange of documentation. They notified you that some of the information they're giving you, the government, the local agency, is proprietary in nature, and they don't want it given out to the public. Okay, that's when you would have to, if you were to receive a right to know request that could include some of that information. Because you've been notified that that information is proprietary, you now have to go back to the vendor and say, look, we've got this right to know request, we just want to confirm your initial notification that this information is private and you would like it withheld. Essentially, you're giving that contractor due process. You're affording them the right to object to a specific request, because the right to know law, again, it has another exemption in it that allows you the discretion to withhold information that's been designated as proprietary in nature. The other example, which as the result of a Supreme Court decision last year, it'll be very rare if you ever encounter this, is if you were to receive a request for public employee home addresses, you would be obligated to notify the employees if you were intending to release any. But prior to that, based on this Supreme Court decision, you would need to conduct what's called a balance test. Prior to this decision, public employee home addresses were considered a public record, and they would be given out. Yet the employees would still be notified because they have a right, again, due process, to object. That still exists now. It's just that if after conducting the balance test, and quite honestly, in most cases, the employee's right to privacy is going to outweigh the public need to release that address. But let's say it went the other way, and let's say it dealt with like a residency requirement of some sort, and there was a compelling reason that you were going to release a public address. Even after conducting the balance test, you would still be obligated to notify the employee because they still have that right to due process. And they have a right to object within the constructs of the right to know law as to why their address should not be given out. For instance, let's say that that employee had a protection from abuse order taken out against a former partner or spouse. Okay, again, going back to the right to know law, there is an exemption that allows you to withhold information if it would result in a threat to personal security. A protection from abuse order clearly meets that definition. And our office has ruled that that is compelling. And despite what your findings are with the balancing test, that exemption, that protection from abuse order that applies to the exemption would outweigh the public interest, because the exemption is controlling in that case. Okay, this is what I was getting at to when I got off track. But basically, third-party records, in almost all situations, you're only required to provide the records you have in your possession. This is the exception. And it's where that vendor, that contractor, that snowplow driver, if you will, has records that are responsive to my request. You get the request, you see that you don't have it, but your contractor does, so you got to go to the contractor, get the record, and then provide it to me in response to my request. That's pretty much how that works. Now let's just say that in the off-season, the snowplow vendor, he's a landscaper, and all of his customers are private homeowners, nothing to do with the township or borough or whatever. Well, all that's off the table, not subject to right to know. Only those records that are representative of the contractual relationship that exists between the snowplow vendor and the government would fall under the umbrella of the right to know law. Okay, the agency response, like I said, you have 5 business days in which to provide an initial response. If you're mailing that response out, it would be based on the postmark. But nowadays, most of our communications email, so it's not an issue. The postmark is what you would look for as you're mailing it. Let's say that you're not able to provide the actual records within the 5 business day period. Well, the law allows you to take a 30 calendar day extension in which to provide the records. However, you have to take that extension appropriately. It's a unilateral extension. You don't need the requester's permission to do so, but you must notify them appropriately. That notification needs to go out within the 5 business day window. You can't wait until the 6th day, suddenly realize, oh my gosh, I forgot about that request, and invoke the extension. Unfortunately, you've already missed your deadline. You've done what's called a deemed denial, where you failed to respond within the initial 5-day window. So you've got to get that extension request out within that 5-day window for it to be appropriate. You need to do it in writing. An email is fine. You need to provide a reason as to why you're taking the extension. Fortunately, the right to know law has a list of 7 reasons that you can. A lot of agencies will simply come up with a form letter template, and they will check off the appropriate reason. It could be we keep our records off-site, and it's going to take us longer than 5 days to go hunt them out. It could be we want our solicitor to review what we're going to provide in response to the request to make sure we're not giving out something that we're not supposed to. And it's going to take our solicitor longer than 5 days to go through these records. It could be simply, given the nature of the request, it's going to take longer than 5 days, meaning this is a big request, and it's just going to take us, given our staff limitations and so forth, it's going to take us longer than 5 days. I think the law is very liberal in how it allows you to invoke that extension if you want to. You provide the requester with the date in which they can expect your response. Surprising number of times, it's usually on the 30th day of the extension. And then also you would give them an estimate of any costs they can expect to incur. And it is just an estimate. It's not like you're giving them a hard quote. So when it comes time for the actual exchange of records and payment, yeah, it could be a little higher, it could be a little less, but it is an estimate that you provided. And then finally, I just want to emphasize that it's the 5 business days plus the 30 calendar days. So we refer to it as a 35-day window. The 30 calendar days get tacked on to the end of the 5 business days. It is possible to get a further extension, but then at that point you need to have the agreement of the requester and get it reduced to writing so that there's no misunderstanding as that additional extension. But that's the law does accommodate that. Okay, let's talk about payment issues, because there's always a lot of misunderstanding when it comes to this. And I also think it presents some useful tools and guidance to you at the agency level when it comes to payment issues. The first, and I think this is a useful point, is that you are only required to provide the record in the medium in which it exists. What does that mean? Well, basically, it's hard copy versus electronic. So let's say that I were to submit a request for a copy of the budget, but I want it electronically because it's easiest for me and it's free. But you only have the budget in hard copy. You don't have an electronic version. Well, you can deny my request because you are not required to convert a record from one medium to another. You are not required to scan that budget in so it can be emailed to me. Conversely, let's say that I'm looking for emails, but for whatever reason, I want the emails printed out into hard copy and mailed to me. You don't have hard copy versions of the emails. You only have the electronic versions that are residing on your server or on someone's personal computer. Well, you are not required to print out those emails because they exist in electronic medium and I'm requesting them in hard copy. So you can deny my request accordingly. Now, if you have them in both, then problem solved. You simply give it to me the way I want it. If I want it electronically, that's how you would send it to me, and there's no charge for electronic records. If I want it hard copy, that's how you would send it to me, and you can charge up to 25 cents a page, 8.5 by 11, single-sided black and white. That's per our fee schedule on our website. If you wanted to, at your discretion, you could scan in a record and email it to me if that's how I requested it. But again, you cannot charge for electronic records. If you wanted to, at your discretion, you could print out those emails and send them to me. And again, you can charge that 25 cents a page. You can do that. You cannot charge for electronic records, like I said. On the right to know form, a person can select, I want to inspect records. I don't necessarily want copies. I just want to inspect them. So you would arrange a mutually agreeable date and time where they could come into your office, maybe sit at a table or a desk, go through the file. If they happen to pull out a cell phone camera and take a picture of the records they are inspecting, they're allowed to do that. The law says, as a matter of fact, they can bring in a scanner or a copier and make their own copies, as long as it's not disruptive to your office operations, okay? As long as they're not getting in the way. The cell phone scenario, quite honestly, I think that's a good thing, because the alternative would be for them to interrupt you in whatever you're doing. Say, hey, can I get a copy of this, please? And you'd have to go over and make that copy, and then if you're invoicing, you got to go through all that. So just let them take the picture, and you know, we're out of your hair that much sooner. And the law says that they can do that. You cannot charge for labor, you know, the time it takes you to assemble records in response to a request. You cannot charge for redaction, and you cannot charge for legal review. The exception with redaction is where a person has requested electronic records, you're granting that request, but let's say that there's a piece of confidential information on that record, a Social Security number. So you would have to print out that record, take your marker, redact that Social Security number, scan it back in, and then send it to me electronically like I've requested. You can charge me for that piece of paper that you had to destroy in order to redact. It's just that under that scenario, I strongly suggest that you notify the person ahead of time. Look, even though these are electronic records, there may be some charges because of redaction. Again, that way there's no surprises, and we encourage communication back and forth between the requester and the agency to ensure that those surprises don't take place. You can only charge actual cost or the pass-through cost. You know, I used the example of the blueprint earlier. let's say that you get a request for a copy of a print and you've decided, yeah, it is responsive, but you don't have a large-scale copier. So you got to run down to Staples or Kinko's or whatever, and they'll make a copy for you, but they're going to charge you 18 bucks a sheet. You can pass that $18 on to the requester. You can make them pay for the copying charge. Same way with postal costs. Let's say you assemble your responsive records, you put them on the meter. It says it's going to cost you $3.15 to mail these records out. You can add that $3.15 onto the invoice. Okay, how you go about your invoicing process and so forth, again, the law is silent on that. That's up to you. Whatever you use for other processes, you can use for your right-to-know administration.
George, with respect to postage, you talked about notification earlier of third-party contractors and also of agency employees. Is the cost of notifying those entities, is that also a cost that can be passed on to the requester?
I don't have a definitive answer for that, but my initial impression is no, you cannot pass that on. But I'll check on that. If you could make a note for me, I'll check with our staff since I'm not 100%. Did everyone hear Chad's question? That if you're required to notify a third party, and you do that by mail, is that cost, who eats that cost? Is it the requester, or is it the agency? And my response was, I don't really have a definitive answer at this point, so I'll get back to him. Okay, additional payment issues. Well, like I said, no surprises. When you receive a request, do a quick estimate. You know, it's like, okay, this report is 100 pages, this file, et cetera, and then pick up the phone or send an email back to the requester. Say, I did a quick estimate of your request here, and I think it's going to cost about $30. Are you okay with that? They're either going to say, whoa, wait a minute. No, I didn't realize there was a cost. I'm going to withdraw my request. Or, yeah, that's about what I figured, no problem. The worst thing is that you receive a right-to-know request. You put several hours worth of work into it. You get, you know, a big stack of papers, copies that you've made. You call the requester, say, hey, we've got your response ready. You can come down and pick it up. The next day they come walking in, and, you know, it's a beautiful day. And everybody's happy, everybody smiles. It's like, okay, well, here's your response, and it's $30, please, and you get that look. Wait a minute, I thought this was free. These are public records, right? Well, yeah, but this is the right-to-know law, and we're allowed to charge, you know, here's how we figured out your bill, and it's $30. But my tax dollars already paid for these. You know, I shouldn't have to pay for these twice. And you know what? You work for me. You know, my tax dollars pay your salary. And I don't think I should have to pay twice for these records that are mine and they get, you know, upset and they turn around in a huff and leave. And you're stuck with $30 worth of records plus all the hours worth of work you did for nothing, right? So call the requester. Make sure everybody knows what to expect. And that way there are no surprises and the law will work, you know, seamlessly, hopefully. Now, it's ideal to have a mutual exchange. They come walking in with their check. You've got the records and, you know, you pull one of these, they take the records and run home, and you take their check, run to the bank, and make sure it clears. But the law says records are provided upon payment. That means push comes to shove, they pay first, and then they get the records. Now, if it looks like the response is going to cost more than $100, you can ask for the full payment up front before you begin processing the request. Okay, so you send them basically your estimate that exceeds $100. They give you that initial payment. You then process it, and then you settle up when it comes time for the actual exchange of the exact number of records for the exact cost of the response. That's how you would take care of it. In excess of $100, you ask for the money up front. If you provide a response that the arrangement is such that they're going to come down and pick it up at your borough office, at your township or county office, the law says you have to hold on to the response for 60 days, 60 calendar days. If they have failed to come and pick up the response on the 61st day, you can take those records that you assembled and shred them or throw them in the trash or do whatever you want to because they have failed to pick them up. If on the 62nd day they come walking in, say, hey, I'm here to get my response, well, they're out of luck on several different levels. First, they still owe you, let's say the $30 for those records, even though you lawfully destroyed them. They still owe you for that initial response. Then if they still want copies of those same records, they have to submit a new right-to-know request and incur any of the costs, probably another $30, for you to go back and make that second group of copies. As a matter of fact, if they want other records that aren't related to the initial request, they're not entitled to anything. You don't have to provide any records until they've settled up their account. Okay, you are not obligated to process subsequent requests if they still owe you for a previous request. And it surprises me how often I run across this situation where the person hasn't paid up, but yet the agency just continues to process their right-to-know request. You don't have to do that. If I could ask you to silence that phone, please. There is no time requirement that basically says, no statute of limitations or whatever when it comes to payments with the right-to-know law. If they still owe you money, then you don't have to process any further requests. Just make sure you have everything documented. Because if you deny that subsequent request, if you fail to process it and you deny providing them records, they can appeal that. However, if you have everything documented, when you submit your documentation for the appeals officer most likely is going to agree with you and say, yes, this appeal is denied, and the agency appropriately denied the request because it's documented here that they never paid for a previous request. You just make sure you've got everything documented and you'll be fine with that. Okay, when you deny a request, basically there's a right way to do it. And you send the letter in writing and first define the records that are in question. Sometimes that's not always clear, so it's good to have it defined on the denial letter. Have the information about the open records officer, because like I said, as part of their duties, that's the person denying the request. Have appeals information on there. How do you do that? Usually it's contacting the Office of Open Records, and then also you would have the date of the denial. Because again, hard deadlines built into this law, that person now has 15 business days in which they could file an appeal. So you need to make sure the date of the denial letter is clear on there. Okay, there is an exception when it involves criminal investigatory records. The appeal does not come to the Office of Open Records, it comes to the county district attorney, and they would handle it. Okay, here's an important point, in that the right-to-know law is not a confidentiality law. There's nothing in the right-to-know law that says you cannot release records. Even though there are 30 exemptions within the law, they are invoked at the agency's discretion. So, if I'm a resident and I come walking into your office and I say, I'd like a copy of the budget, you happen to have a stack of budgets there, there's nothing preventing you from simply picking up a copy and handing it to me. You can do that. There's no requirement that I must file a right-to-know request to do that, as far as the state law is concerned. As a matter of fact, if I do have a right-to-know request, and you've got a stack of budgets there, you can say, Mr. Speece, you know what, it would save me a lot of paperwork and you a lot of time if you would simply withdraw your request, tear it up, and I'll give you a copy of the budget. You can do that. Okay, it's perfectly legal to do that. However, if I say, no, I want to file the right-to-know process, I'm not sure why I would do that, but let's just say, for whatever reason, then you would have to follow the right-to-know process, if that's what I say I want to do. And then you would have to follow through the appropriate deadlines and paperwork. And I may end up having to wait 35 days to get that budget that's sitting there, but heaven forbid that would be the case. even though there are 30 exemptions, like I said, they are invoked at the discretion of the agency. And you could still give records out, even though it's clearly captured within the definition of one of those exemptions. However, if a record is designated as confidential because of another law, that law is controlling, and it trumps the right to know law. Law enforcement agencies have to deal with CREA, the Criminal History Records Information Act, that defines quite a large body of records that they touch on a day-in, day-out basis as confidential. So in response to my right to know request, you would deny it based on the appropriate provision of CREA. And you would say, CREA has defined these records as confidential, and for that reason we cannot release them. Your right to know request is denied. Anyone here have a kid in college? Yeah, how do you see their grades? Well, you don't, that's right. That's right. Unless, under FERPA, the Family Educational Rights and Privacy Act, they have signed a waiver where they are giving you permission to access their grades, right? I've got 2 kids in college right now, so this is near and dear to me. You know, I'm paying for this party, and I can't see their grades, you know? But FERPA basically says that all individual educational records are confidential, and they cannot be released without permission. Okay, school districts deal with this all the time. Anyone here work in HR, they're familiar with a law called HIPAA, which makes it illegal to give out personal health information. Well, right to know request for a record of that sort, you would deny that request based on the provisions of HIPAA, which basically say it is illegal to release records of this sort. Even though it may not be covered by the right to know law, the other law is prevailing. The other law trumps right to know. Also, if a record is protected by privilege, let's say you've got a solicitor providing advice to a board, whether it be borough, township, county, whatever, that communication, emails and memos and so forth, is protected by privilege. And privilege would trump any, well, most compelling reasons within the right to know law for releasing a record. Okay, also a judge's order would trump the right to know law. And I'll just leave it at that. Finally, I want to emphasize again, if the agency head determines that it's in the public interest to release a record, they can do that. 911 calls are a good example. The law clearly states there's an exemption in there that covers 911 calls and recordings, but yet we've all heard them through the media. This is where the county EMA has decided, you know, maybe it'll help solve a crime or prevent a crime or whatever, we're going to release this tape. They can do that. The law allows them to do that. But the big takeaway is that there's nothing in the right to know law that says you cannot release a record. It may be another law, but it's not the right to know law. The exemptions, there are 30 of them. You have them in your handouts. I'm not going to go through each one. I'm not going to go through any of them, as a matter of fact. But if you look at them and then you look at the law itself, where there's an expanded definition of each one, you're going to find it's all common sense stuff. And it covers a really broad spectrum of records. This really represents your second cut. If it's a record, now you're deciding, is it a public record? Does it fall within the definition of one of these exemptions? And if it does, maybe you want to withhold it. Maybe you have a good reason for doing so. So you would invoke the exemption and deny my request. Basically, you're saying it's a record, but it's not a public record because this exemption applies. Okay, so that's your second cut. And like I said, it covers a lot of different material and different types of records. Every one of those exemptions has been tested, either through final determination or a court decision, and every final determination that we've ever issued since 2009, close to 17,000 of them on a searchable database on our website, or they're available through Lexis and Westlaw if you happen to have a subscription to those services. For problem requests, I'll just cover this real quick because a lot of this we've already talked about. Asking the question versus seeking the record. If you can't figure out what the person's asking for, you can deny that request because it's not sufficiently specific. Commercial requests. Let me just raise this. You know, if it's, the law was never intended for public agencies to provide information for free that private concerns would turn around and sell at a profit. There are some proposals to revise the law that addresses this. We're still waiting for some to gain traction. We're cautiously optimistic that may happen. You know, if it's a hardware store down the street and they want a list of pool permits because they sell pool supplies, you probably want to respond to that sort of request. Chances are they live 2 doors down from the supervisor and your kids play together or something like that. If you deny a request like that, there's going to be consequences. But you know, if it's a concern for, let's say, out of state, where they're simply getting email lists for every concern, every township, every county, every borough in the state of Pennsylvania, and they want, you know, let's say they want purchasing information. My recommendation is if you receive a request like that, one of 2 things. Either go to our website and do a search of our final appeals, or call our office and ask the question, have they ever filed an appeal? I know from personal conversations with various open records officers, various managers, that there are some times when they simply ignore a request. If you do that, that requester can file an appeal. But if they've never filed an appeal, in all the years they've been filing requests, that might tell you something, and might give you some guidance on how to proceed with a commercial request. Okay, now, ethically, that's about as much as I can say about it. You guys have to connect the dots. But there's nothing wrong with calling our office, maybe even asking for me, and saying, hey, George, has this company ever filed an appeal? You can do that. You can do that, and I'd be glad to help you out. Tax collectors, under the Pennsylvania Tax Code, tax collectors are exempt. They do not have to respond to right-to-know requests. However, if the tax collector has given a report to the municipality reflecting, you know, tax collections or accounts in arrears or whatever, I can file my right-to-know request with the municipality. And if you're in possession of that report, then you have to give it to me. But you're not obligated to go to the tax collector to get the report, because they are not subject to the right-to-know law. Discovery, you know, there is a process within the litigation world where there's an exchange of information. It's called discovery. Discovery sometimes is controlled by a judge's order. A judge will limit what records can be subject to discovery, what needs to be exchanged. It's a judge's order, and that judge's order trumps right to know. Therefore, if you were to receive a right to know request, that looks like it's what we call pre-discovery. Someone is fishing for records based on litigation. If that judge's order has been issued, then the judge's order can apply to the right to know request as well, and limit the scope of records that you would have to search out because of that judge's order. The judge's order is controlling. It trumps the right to know law. Finally, well, voluminous requests, all I'll say here is that most people don't realize how much they're asking for when they file a right to know request. It's surprising, they don't realize. So if you get a big request, there's nothing wrong with picking up the phone and saying, look, are you sure this is what you're looking for? Because it is a whole file cabinet full of paper, and it's going to cost you quite a bit. Again, communication, no surprises. Also, this might be an instance where you can't require the person to tell you why they're filing the request, but the law says you can't ask. So you could say, look, if you don't mind telling me why you're filing this request, it might help me kind of narrow the scope of what I'm looking for, and I can find you those records. All right? A lot of times people will cooperate with that sort of attitude. You can ask. You just can't require them to tell you in order to process their request. Finally, there's a thing called a disruptive request. The law allows you to deny a request if it's considered disruptive. I'm not going to go into it because of time constraints, plus I don't want to get your hopes up. It hasn't been used much at all successfully to have requests denied, but it is out there. You can explore it if you're curious about it. Best practices, well, adopt an open records policy. It so happens we have a sample open records policy on our website. You're welcome to download it, fill in the blanks, move paragraphs around, do whatever you want. Just adopt it so you have a legally defensible open records policy in place to support your program. We talked about templates. It makes perfect sense to do so. Appoint an alternate open records officer. I realize you may not have a lot of staff, but you know, every now and then your open records officer might like to go on vacation or take a sick day or something like that. Well, if they're out for an extended period of time, an alternate can kind of keep things running. so that maybe when they come back from vacation, all that work is waiting for them, but at least it hasn't been deemed denied. Okay? If you can, appoint an alternate. Agency email accounts and phones, this is a no-brainer. Rather than sitting at home conducting agency business on my personal AOL account, it would make a lot more sense if I had, you know, a township account or a county account that I would limit all of my government business to that. No personal business on that account. Conversely, no township or county business on my personal account. So that when I receive a right to know request, everything's in one place. All right? I'm not mixing up the two and potentially releasing embarrassing stuff that I don't want anyone else to see because I'm putting work business on my personal account. So issue an agency account. At the very least, a Gmail account. You know, johndoe.xyztownship@gmail.com. Doesn't cost you a cent, and you can do that. All right, best practice. Websites as business platforms. You know, I think we touched on this a little bit, but you know, that budget that you keep getting right to know requests for, put it on your website. Okay? That way, next time you receive a right to know request, you can simply say, that record is on our website, here's the link. The law allows you to do that. You know what happens? Hits start going up on your website, right to know requests start going down. And that's a good thing. Okay? Saves you a lot of work in the long run. So use your websites when you notice a pattern of requests for specific records, whether it be budget, purchasing, employee information, whatever, stick it on your website. That's what people are expecting. It's a lot easier, and what they expect for them to sit in the comfort of their family room and surf your website for data than it is for them to take time off of work, come downtown, and file right to know requests and wait for a response. And it also saves you a lot of time in the long run. So it's a win-win. Right to know requests and your responses are considered public records. There's nothing private about a right to know request or the records that you're providing because you've already determined they are public. A lot of agencies are putting all that information right on their website. You can do that. And then finally, develop a records retention policy. I'll simply say this, because the right to know law doesn't mention it, doesn't mean it's not a good thing. The Pennsylvania Historical and Museum Commission, PHMC, has a great website with information, a sample records retention policy. They have staff that provide excellent training, and they've actually come out to your site and help you develop a retention policy. I'm not going to go into great detail other than to tell you it is a good thing to have a records retention policy on many different levels. Okay, I'm going to run through very briefly appeals because I'm getting behind here. Basically, the person who's denied a request has 15 business days in which to file an appeal, usually with the Office of Open Records. We look for a complete appeal. We need a copy of the original request, the original response if it was provided. The person has to tell us why they think the records are public and why they think the agency is wrong. Okay, we give them one chance to make sure all that is there. If not, we dismiss it because it is deficient. They get one chance to correct it. We docket the appeal, it gets assigned a number, it gets assigned to an appeals officer, and we send out notification to all the parties that we have an appeal with instructions as to what they must do. If you're working in an agency and you get a notification that an appeal has been filed, the biggest thing you can take away from here today is that call your lawyer. Let your solicitor know that you have an appeal because they must deal with it. They're the point person now, not the open records officer. Everything I've talked about up till now is an administrative process. When an appeal is filed, you're in the legal world now. And appropriate form and process and procedures must be followed in order for your response to be considered appropriate and of rising to the necessary level that it needs to. Don't try to handle it yourself. Contact your solicitor. Okay, that's the best advice you'll hear here today. Okay? The product of an appeal is a final determination that if you were to see one, it looks just like a court decision. It carries the weight of law. And like I said, all of those are available on our website and through Westlaw and Lexis. There is the option of mediation. I don't have time to talk about it. In-camera review, that's where if we issue an order for in-camera review, basically we're ordering you to send us the records so we can look at them to determine whether or not they should be released to the public or not. Our decisions can be appealed to a court, into the Berks County Court, let's say, and a judge would then review, but you have to tell us if you're doing that, if you're appealing, because we may, in fact, choose to get involved in the litigation at some level. Our office cannot issue fines or assign attorney fees, but a judge can, and they have been known to do that. Most recently, the Philadelphia court fined the Philadelphia district attorney $500 for acting in bad faith relative to a right to know request. So it does happen. You catch a judge on the wrong day or the right day, depending on which side you're sitting on, and a judge could lower the bill money. Okay, let me move into the sunshine law. And we'll try and cover that. I think we're running pretty good here. I've been talking about Pennsylvania's right to know law. That is public access to public records. We're now going to talk about Pennsylvania's Sunshine Act. Our office doesn't have any authority over the act, but we're tasked with providing training on what that act entails and what your obligations are. The Sunshine Act involves public access to public meetings. Okay, and has a different set of dynamics, although the two laws do cross every now and then. Okay, who is covered? I think you can pretty much apply the same standard that's included in the Right to Know law to the Sunshine Act as to who falls under the Sunshine Act. It's any state or local government body. The difference, well, not so much a difference, but the point you need to be aware of is that it includes the term committees. And this can be very subjective, but the bottom line comes down to, is that committee providing a recommendation to the main body that ultimately they would render a vote on? If that's the case, then chances are the committee would also be subject to sunshine. And it doesn't have to have a quorum of board members on it. It doesn't even have to have any board members on it. The way the law is written and the way court decisions are leaning lately, it's in favor of transparency. So that committee, if they are providing a recommendation for board action, then chances are that committee is also subject to sunshine, and you would follow the requirements of the Sunshine Act. They have to be performing an essential government function. So, I use this example. If it's like covering revisions to the zoning ordinance, yes. If they are, put together to organize the Memorial Day parade, I wouldn't worry about it so much, because the recommendations they're providing, they're probably going to get approved even without a vote, okay? But you look at that, is it an essential government function? And if so, again, Sunshine Act would apply. They exercise authority or official action, and this is where that committee language comes into, because under the definition of official action in the Sunshine Act, it says making recommendations. So, making recommendations defined under official action, and under the Sunshine Act, it's taking official action. So, it would apply for the committee scenario. Okay, one of the requirements of the Sunshine Act is public notice, that these meetings taken by the board, there needs to be public notice prior to the meetings being held. At the beginning of the year, when there's, like what we'll call the organizational meeting, 3 days prior to that, okay, there needs to be public notice in a newspaper of general circulation. It used to be the Reading Eagle. Is that still the Reading paper? Are they 7 days a week or?
Yes.
Okay. In Harrisburg, the daily paper is actually only 3 days a week. That's the trend. It's becoming a problem. There are some proposed revisions to the Sunshine Act that would address this through website advertising and so forth, but nothing's been voted on yet. The law has not changed. A newspaper of general circulation, 3 days prior to your organizational meeting. And then you would include all the dates of the regular meetings throughout either the calendar or fiscal year, that when the board is expected to meet for its regular meetings. Okay? You also post it at the meeting site. You can have special meetings that would not be on the regular schedule, like every third Thursday or whatever. Let's say for some reason you've got to meet this Tuesday for an important issue. you can do that so long as you advertise 24 hours in advance. You can do that for a special meeting. Okay? Public comment is another issue. This is probably the area where we receive the most complaints related to sunshine. Under the Sunshine Act, at a regular or special meeting, the public is entitled to comment on issues before the board, or expected to come up before the board, before they vote, they actually vote. Some agencies will simply have a general comment period, which is basically a free-for-all. I can complain about anything I want to, and then they may have a second comment period, purely for issues before the board, on the agenda coming up for a vote. You don't have to do the first if you don't want to, but you must do the second. And you have to do it before the vote takes place. The board can establish reasonable rules. Basically what this means, usually it means time limits. Only 3 minutes for each commenter. You can do that as long as your intent is not to subvert the ability of people to comment on it. And I should mention also, the law says you can limit comments to residents or taxpayers. For instance, if I'm part of a public advocacy group from out of town, and I want to make a public comment at your local meeting, you don't have to let me do that. The law says only residents or taxpayers. Just make sure that you apply your regulations or your practices uniformly. Don't let one person who's in favor of your ordinance stand up and talk for 20 minutes, and then the next guy comes along who disagrees, you shut him down after 90 seconds. You can't do that. So you need to be equitable, you need to be consistent in whatever rules you come up with for public comment. Just try to do the best you can. Like I said, this is the area we receive the most complaints about, where people think they're not getting a fair say in the activity of their local government. Executive sessions, it runs a closed session. Okay, you are allowed to meet for executive sessions, provided it's held in concert with an open session. Okay, so it can be before the meeting, it can be during the meeting, or it can be after the meeting. But it must be related to a regular open meeting in some way. You can convene a special meeting that's pre-advertised just for the purpose of going into executive session. But you must convene first, you advertise a special meeting 24 hours in advance. You convene the special meeting in public, and then you immediately go into executive session. You can do that, okay? But you must have that open meeting that takes place. When you're going into executive session, you must provide a complete reason. You cannot say, we're going in to discuss litigation. No, you've got to be more open about, maybe the name of the case or what the litigation is about. And I realize this is a tough one. You've got to weigh the need for openness versus, sometimes a need for discretion or confidentiality. Like, you can't say we're going into executive session to discuss personnel issues. You've got to do more than that. But then, if you turn around and say we're going into executive session to discuss a disciplinary issue regarding one of our employees, and you only have one employee, yeah, it can be a problem. So, you've got to balance. The actual case that has some useful language in it, I believe, involved the city of Reading. And it basically says you've got to provide enough information so that the public can determine you're not violating. That's a tough one. You've got to prove a negative. But you do the best you can. I realize sometimes it can be subjective. But I think that court case provides some useful language. You cannot take any official action during an executive session. Meaning, let's say you're meeting to decide whether this employee should be disciplined or not. During the executive session, you can come to the conclusion that, yes, it's appropriate to render a 2-week suspension. Okay? But you must come out of executive session into public session then and vote on what you've kind of decided what to do. Okay? Any official action, any decision making must be memorialized through an official vote that is then reflected in the minutes of that meeting. Okay, the law allows you various reasons for going into executive session: personnel matters, discussing labor negotiations, considering the purchasing or leasing of property, not the sale of property. If you're thinking of selling property, you must deliberate and decide that in an open forum. Talking to counsel about potential litigation, violating privilege or confidentiality. Again, this is where you've got a need to discuss something with your solicitor that for whatever reason you cannot discuss in public because it might violate privilege to do so. And then finally, I don't know how this ever got in the law, but if you're going to discuss university admission standards, you can do that in executive session as well. Okay, so just miscellaneous points that seem to be for the good of the order that everyone should know about. You must produce meeting minutes. The law says, it uses the word keep. You must keep minutes, which is somewhat vague, but everyone seems to be able to figure it out. There's no time limit on when the minutes must be produced, but hopefully you do that as soon as you can. There's no requirement for an agenda. So again, we get complaints about, the township doesn't even have an agenda when they go into meetings. Well, the Sunshine Act doesn't require an agenda. If you can do that, I think it's good. People would like to see that, but you're not violating the Sunshine Act if you don't happen to have an agenda. The public can record public meetings, and they don't have to tell you that they're recording. Okay, it's not a violation of Pennsylvania's wiretap law if I should happen to turn my cell phone on record before I walk into a public meeting. I can do that, and it's not violating wiretap. I think probably best practice would be for the chairman at the beginning of the meeting to announce that this meeting very well could be recorded by either the agency or any member of the public. They're allowed to do that. You can establish reasonable rules for recording, though. For instance, I can't, as a citizen, say, "Oh, excuse me, you mind just taking a break here? I got to change the batteries on my recorder." No, I can't do that. And you can tell me that I can't do that. Same way with TV stations. You can say, we'd like you to set up over in the corner there, out of the way, and we don't want your lights shining on the board or any member of the public because it's distracting. Stuff like that. Again, as long as you're affording the public the right to do what the law says they can do, you should be okay with your regulations and laws. All right? We already talked about recordings of minutes. And then finally, you can cure violations. Let's say that you went into executive session, decided a 2-week suspension is appropriate, but you forgot to vote when you came back out. And let's say the next night you're sitting at the dining room table and, oh man. Well, you can convene an open meeting to cure that violation, and you'll be okay for doing that. All right? You can take a subsequent vote if you forgot to take one beforehand. And as long as you're doing that in good faith, you'll be okay. All right, the final slide is basically additional resources. The worst thing Ronald Reagan said you could ever hear was, "I'm from the government and I'm here to help." Well, that's me. If you have any questions, feel free to contact our office. Go to our website first, check things out. We've got FAQs, we've got guides for just about everybody and everything there that you can download for free. All kinds of resources, all those final determinations I talked about. If you don't find what you're looking for, we've got email accounts and phone lines just for you to call in and ask for help. 2 things. If you call our office, we do our best to make sure you don't get the machine, that you talk to a human being. And the second thing is that if we can't give you an answer right then and there, we will get back to you within 24 hours. If you're going to call our office, it's something important and it's something time sensitive, and we're going to treat it accordingly and give you the respect you deserve. So we can't provide legal advice, but there may very well be a factually similar case that we can steer you to where we've already rendered a decision. And if it's something new, then you'll get all kinds of attention because we love new stuff. We love sitting around debating new issues that we've never encountered before. So we'll try and help you out. But thank you for coming here today. Hopefully we've given you some useful information. I'm going to hang out as long as it takes. If you have any questions or comments or whatever, I've heard just about every bitch I ever could hear about the right to know law, but if you feel you have to talk to me about it, I can handle it. I've got big shoulders, okay? But thank you very much.